Doing all right? Good to see you.
Love these business cards from lawyers. When you might need them.
I got an email from Kathy. She told me she was on spring break. Whenever you're, I've got a couple more of these.
I'm live now.
Okay, I'm just gonna sit these on.
Okay, sounds great. I'll sit wherever you want.
Yep.
Good, how are you? Thank you so much. This is where I can feel all the kids in HR.
Good afternoon. Welcome to Wednesday. We're certainly glad to have you. We're here with the new knowledge. And today we have Mr. John Martin with Penn, Stuart. John, great to have you.
Thank you. Thank you. Bear with me for just a second. So, thank you all for letting me come and speak to you, and I hope that I don't bore you to death. The subject that we're talking about is not exactly the the hottest topic, but it's one that we're all going to deal with for a long time. And as we'll talk about, it's a fairly old statute, covers a lot of ground, and usually it always brings about some discussion on the congressional front as well. So. My name is John Martin, and I'm an attorney with the law firm of Penn, Stuart. I'm a shareholder in our Bristol office. My practice primarily focuses on employment defense work. I do a lot of workers' compensation defense. I do the occasional smattering of more involved employment law matters, and then some general business issues. So Fair Labor Standards is something that I don't practice a whole lot, but I have some interest in, and I have a couple of cases going on right now. But I will put full disclosure out there and tell you that I'm in no way an expert. I think my outline is maybe 8 or 9 pages, and I will tell you I try to stay up on as much employment law work as I can. So I'll attend seminars and such, you know, like we all do to keep our credentials. A couple years ago, well, actually this last March, I was at a seminar where I saw the best speaker on Fair Labor Standards that I've seen in a long, long time, and her outline was 189 pages. So we're, you know, if I tell you we're scratching the surface, I'm probably lying to you. Let me begin just by asking everybody, who has direct responsibility for their pay rate and their payroll issues in their job? Okay, so some, but everybody's tangentially involved in it.
John, it might help you if everybody go around the room and introduce themselves. And
Sure, would love to know that.
Would help you pinpoint. So.
Absolutely, would love that. Thank you. We'll start with you all and then work our way around.
My name's Patty Pasco. I'm a general manager at the Abingdon Cinema.
Okay.
Will Hayes, assistant manager at the Abingdon Cinema.
Okay. Thank you.
John Bolden, technical assistant, Chilhowee Fire Department.
Okay.
Trish Henderson, Human Resources Director for the City of Bristol, Virginia.
Thank you, Trish.
Samir Patel, owner of Comfort Suites.
Okay. Thank you.
Michael, manager at Comfort Suites.
Okay. Thank you both.
Holly Dale, just a very small business, so I kind of want to get a taste of what it's like to have employees.
Very good. Thank you. All right. Welcome. Okay. Well, along those lines, as we go along with this, I will try to hit the highlights of the Fair Labor Standards Act as I know it, as I understand it. If at any time you have a question, I beg you to put it on the table, because I think those are the better discussions. You know, if you want to know something or some aspect of what we've just touched on, is relevant to you, please let me know. I'd rather dig into that than just drone on about something that may not be so interesting to you. So I will tell you that, like every good speaker, I did my outline, I closed the document, I hit print, and then I realized I left out a couple of things that I wanted to put in there, so I apologize. Let me start with just a little bit of an pre-overview for the Fair Labor Standards Act. So the Fair Labor Standards Act is one of our older employment laws. It goes back to the FDR administration in 1938. It was pretty far thinking then. It's been with us so long now that everybody understands that it is what we have to live with. Like all federal statutes, it was enacted by Congress. So if you're ever interested in trying to learn more on your own about it, you start first with a statute. And then, as with most congressional statutes, there's an administrative overlay that goes with it. So the Department of Labor, more specifically the Wage and Hour Division, is tasked with administering the Fair Labor Standards Act. They have quite a bit of authority and quite a bit of ability to look at your records and things like that. We'll touch upon that just in a little bit. But one of their primary responsibilities with the Fair Labor Standards Act is to issue regulations that interpret the statute. So the statute itself may not be crystal clear on something, but with a statute that is as old as Fair Labor Standards, the Department of Labor or its predecessor has pretty much seen most of the questions. And so the regulations tend to be fairly informative. So, you know, if you do find yourself looking at one of these questions and you need to, you want to try to figure it out yourself, the Code of Federal Regulations is probably the best place to look. All of that, of course, is available online. In addition to the congressional oversight and the administrative oversight, the federal courts have oversight, as you would expect, over the federal legislation. So a lot of times questions and concerns that may be addressed in both the statute or the regulations may have been litigated in court. And so sometimes when you're looking at the regulation, that may not be the last answer on the question. So federal courts go from the court here in Abingdon and other district courts just like that, all the way up to the Supreme Court. So the Supreme Court usually has the final say on these types of issues. There are lots of cases involving Supreme Court interpretation of Fair Labor Standards issues. But in addition, and one of the more user-friendly aspects of it, the Department of Labor itself has interpretive power over the statutes and the regulations. So it is possible, if you have a question, to send a letter outlining your issues to the Department of Labor, and they will issue you, in most cases, their own finding or their own recommendation about how this issue should be played out. So you can look online. There are all kinds of letters from the Department of Labor that issue their own interpretations. That interpretation, I would tell you, is, it's very helpful. It gives you an idea of what people who deal with this every day think about the Act and the statute. But you got to remember that statute itself, that ruling itself is subject to challenge through the courts, and it may not always be the end of all discussions. So those are just some helpful places to look online to find answers if you really do find yourself in one of these questions, okay? Before we get started, any questions about that? And like I said, I wanted to put that in the outline and completely forgot about it, shut it down. So the Fair Labor Standards Act itself, as I said, it is fairly lengthy, or fairly old. 1938 is a very old statute for employment law matters. It basically sets out 4 criteria, and there's a lot of misconceptions. We'll hit on a few of those later. There are a lot of misconceptions about what the Fair Labor Standards Act does and doesn't do. But the primary components that you would want to be concerned with, it establishes first the minimum wage, then it establishes the overtime regulation or the overtime requirement, which is basically a second wage, if you will. It's 1.5 times the minimum wage in most cases. And then the part that I would tell you as employer-oriented individuals, the part that I would tell you is probably as important as anything is the record keeping. So it requires us to keep records, and it requires us to have those records available for certain periods of time, but it's surprisingly quiet on what and how you keep records. There's no computerized requirement. There's no published requirement. But as an employer, the Department of Labor looks at you to be the one to be responsible for keeping accurate and clear records. So, interestingly, you look at who it affects. Basically, it affects full and part-time employees. And I would point out right now that there is no statutory distinction between full and part-time employee. There's only the 40-hour cap and then the 40-hour excess payment. So, when we say, oh, the federal government says I'm a full-time employee, you can be part-time and work those hours. Usually when we're talking about full or part-time employment, we're talking about other aspects, like maybe whether you qualify for your health care or whether you qualify for some other policy or some other benefit that you offer based on a similar requirement to the 40-hour work week. But the 40, in terms of the statute and Fair Labor Standards, it doesn't discern, it doesn't clarify or define a full or a part-time employee. But people that we call full or part-time employees are affected by this. So if you have a part-time employee and they work 45 hours, they're going to be entitled to overtime regardless of the classification. Then you look at the area of who is covered in terms of employers, and I won't labor on it too long. The basic rule is that if it was an enterprise that dealt in interstate commerce and it made the enterprise earned in excess of $500,000 in a year, you were basically covered. But this is the part that I would tell you to be very cautious about. The Fair Labor Standards Act requires an employer to perform that test to see if the employer qualifies and is required to participate in Fair Labor Standards record keeping. But it also requires you to look at an employee who may or may not be covered under the Act. And so the second part of this is really the employees who are actually considered to be covered. And it's been a little while since I'd looked at the statute, but if you go all the way down to Section 3, if you have an employee, the standard consideration for an employee is that if they're involved in interstate commerce, then they're going to be covered. But if you look at what some of the examples from case law and regulations on what is now considered interstate commerce, obviously the traveling out of state, we think about that, that's as old as time for the Act. Making interstate phone calls, you think about it, years ago you didn't do that. It was a big deal to make a long distance call. We all waited till after hours to make those calls, so you frowned on it. We usually sent mail. But now the one that I think is probably going to make just about every employee in the country subject to Fair Labor Standards requirements is if you send an email, and that's an interstate transaction. If that's part of your regular job, then you're covered under the Fair Labor Standards Act. So the important thing to remember about that aspect of the Act is the Department of Labor and the statute requires every employer to do a dual screening. So you ask yourself as an employer, do I qualify? Am I supposed to participate? Am I supposed to pay pursuant to Fair Labor Standards? Do I have employees? If I'm not at 500,000, do I have employees who are subject to the Act by virtue of the fact that they participate in interstate commerce? So, in today's world, I find it hard to think of anybody who wouldn't meet that test. Other examples of entities that are automatically covered by the statute: healthcare providers. So those are hospitals, institutions that take care of individuals with long-term illness, nursing homes for the aged, nursing homes for individuals with specific disabilities, specialized care treatment facilities. Then you look at the government entities. Pretty much all federal, state, and local entities are going to be covered for purposes of their employees. So the statute just says, we don't care about, because obviously when the statute came into being, you didn't have to worry about government entities making, doing business at certain levels. So as a result, government entities were automatically roped into the statute and the requirements for the statute. Institutions of higher learning and I was kind of interested and started to look at that, and I went back to be certain. While primary, secondary, and preschool entities are automatically considered part of or enterprises that are required to pay pursuant to Fair Labor Standards requirements, if you go back and look, there are certain regulations that exempt teachers. So if you've got teachers on your staff, they're probably going to be exempt no matter what the situation is. We'll get into that. I'll hit on the exemptions, non-exemptions here in just a minute. But interestingly, even though the government decided to bring in these specific articulated government entities, local, state, federal, and local entities, that's a major aspect of primary, secondary education that really aren't affected by that, or is immediately affected. Then you look, and there's a few enterprises that are not considered. Most of those tend to deal with elected officials and the jobs that are being done by elected officials, so that's considered. Yes, ma'am. Absolutely, beg you to.
As a member of the public sector, we have constitutional offices, which is treasurer, commissioner of revenue, secretary of state, sheriff's office, and homeland attorney. So they themselves as elected officials would not be covered or exempt from the overtime. And here it says members of their staff, so if we have clerks in these offices, are they
Great.
considered?
Yeah, that's a great question, and that highlights how this seemingly clear statute can be kind of confusing. It's my understanding from just the things. This outline is put together from several different sources, and the typical understanding that I have of when it says staff would be if you're a member of the House of Delegates and I'm your Southwest Virginia, telephone connection. I'm working for you as a staff member. I would not necessarily be required. You would not necessarily be required to pay me pursuant to to FLSA requirements. But when you're talking about clerks and deputy clerks, I think there's a clear distinction because those are actually the people who are doing, full-time regular work. And my understanding of the elected official exception, if you will, is that those people, because in state and local levels, they're considered in many cases just to be part-time officials, and it's understood that their staff may be part-time officials as well. So my gut reaction would be that when you're talking about, you could carry that example out to, sheriffs. Obviously, we know that sheriff's deputies qualify for overtime, they qualify for certain pay requirements. So I would say that the same would be true for like the clerks, the commissioner clerks, the treasurer clerks, those folks. Does that help?
Yes, thank you.
Okay. And let me pose too, as I mentioned earlier, I think this is, my hope was that this just sort of gave everybody kind of a working sheet of paper to look at if you had a question. It's by no means exhaustive, and it's by no means, what's on it today may be inaccurate tomorrow, because this is an area that can change with some fluidity. But if you run into a question, you have a question or something like that, and if I don't know the answer, if we feel like we need to look at it, I'm happy to try to help to look it up and see if we can, if you can't find a source that suits you, that's the sort of thing that we'd be happy to help with. Interestingly enough, immediate family members of farmers are still not covered by the Fair Labor Standards Act. So you can still have the family farm with, like we used to have in days gone by when the family, had several kids to help work with the farm. That's still exempt, or still not covered under the Act. Which gives you an idea of how old the Act is, because that was a significant sector of the population when the Act was put into place, and that segment of the population had a lot to say in how this statute affected them. Then there are a couple more, and those are just some examples. They're by no means exhaustive. The regulations are the best place to find those answers. Coming down then to Section 3, and this is really where the discussion lies. When you're talking about, Sandy, we go till 1, is that right?
1:30.
Okay.
These folks.
Okay. So if you look at the components of the Fair Labor Standards Act, as we talked about earlier when it sets out what it does, the first part that you start with is the basic minimum wage. Now there's a basic minimum wage, and as you'll see right below that, there's a sub-minimum wage. And the basic minimum wage is the first part of the building block, and that's established by Congress. It's still $7.25, and it went up in 2009. It hasn't gone up in some time. I put a note on here to just remind everybody, you know, you don't turn on news these days without hearing some discussion about a $15 an hour minimum wage. You know, the segment of our population that's in favor of that has distinct beliefs about what that's going to do for the economy and for people, and we talk about a living wage. The segment of the population that's opposed to it says, no, you're setting up a situation where you're going to eliminate lower paying jobs, and that the basic minimum wage was not designed to be a living wage. It was designed to be an entry-level wage. Wherever you sit on that spectrum, there's quite a bit of discussion in both directions, always. So much so that you pick up the paper or you turn on the radio and listen to the news. Cities and states are implementing their own version of minimum wages. And while the Fair Labor Standards Act requires all covered entities to participate at the minimum level, it does nothing to say this is your coverage. You can't go to the Fair Labor Standards Act and say my minimum wage is $7.25 because that's what Congress says. So if you're in a locality that decides they want to increase the basic minimum wage, you can be required to participate in that minimum wage payment just as much. And typically what happens is those localities that do that will set the wage where they want it and then say, and all other requirements of the Fair Labor Standards Act must be enforced. So it's just a way to tag on and quickly bump the wage. So, you know, at the end of the document, I have a little sheet that I pulled off the internet, and I forgot to put the attributing site, but that's just an example of state-required minimum wages across the country. So as you can see, there's increasing pressure. We may see that wage come up as a general rule.
And John, for those that are watching online, we can email them this document, can't we?
Yes, ma'am. Absolutely. Yeah. Yeah. And my apologies for not having a PowerPoint. PowerPoints scare me. So, and as some of you may be aware, there's a sub-minimum wage. That's usually what we refer to for tipped employees. And even with a sub-minimum wage, there's a requirement that the employer has to be able to show that the combined tipped wages and the sub-minimum wage that you're required to pay will exceed $7.25. Again, the regulations talk about what you have to do to meet that. So if you have any questions, if you have tipped employees, you may want to look at the regulations to make sure, because sometimes what we think is appropriate may be missing. So anyway, the two together, though, have to basically hit on an average the minimum wage, the basic minimum wage. I put a note in here saying that employees may pay special wages for individuals with disabilities as an incentive to bring folks into things like sheltered workshops and learning facilities. I really am not familiar with any situations like that where that may happen, but that's something to look at and consider if it may affect your business. The second part, in addition to the basic minimum wage, is the overtime. Of course, we're all familiar with the requirements of overtime. You know, you have to pay the minimum wage, and I'm going to go into that. For now, just think of it as a minimum wage. But when you talk about that and you talk about the requirement's up to 40 hours, you have to pay it that wage. If you exceed 40 hours, for the hours over and above 40, of course, you have to pay time and a half. As we'll see when we get down into the rest of the outline, again, the statute, while it has its basic directives, it can be fairly confusing. It doesn't provide a specific time when you have to pay. So you can pay, you could feasibly pay daily if you wanted to. You could pay weekly. You could pay every 2 weeks. You could pay twice a month. You could pay monthly. But the requirement for overtime is you have to pay the overtime in the calendar period. I mean, in the pay period in which it was earned. So you can't hold overtime for 3 months and then pay it as a collective. So if you earn overtime in whatever your defined pay period is, you have to pay that overtime when you close out that pay period. On the government side, as you know, they make provisions for compensatory time. So if you have time, you're going to be over 40, you can take those. You're permitted, subject to local government or governmental entity policies, you're permitted to take that additional time as compensatory time. And I know when I worked as the county attorney, we would always have the bi-weekly meetings for the board, which, as you know, can run late into the evening. And our rule was that you took that time in the month in which it was earned. So if you had 8 hours over, you had to take that 8 hours in that month or you forfeited that time. So that was just the policy, but that was how we were permitted to take comp time. So this is probably the part that I get the most questions on whenever I deal with Fair Labor Standards Act situations, and that's exemptions. Who's exempt? Who can I exclude from the overtime rule? Because the way the statute works, if you are a non-exempt, in other words, if you're generally everybody in the United States, there's almost a presumption that you're going to qualify for overtime salary. If it's up to the employer to show that their employee falls into one of the exempt categories. So is everybody familiar with that concept of exempt and non-exempt employees? Has anybody never heard of that before? So the regulations are very clear on these things. In fact, they may, in some instances, the regulations go so far as to say this person is, they don't just generalize by criteria, they'll just say, if you do this job, you are non-exempt. And the reason is, the preference is to put people on the overtime pay side of the ledger. It's possible to do jobs, to have dual duties where one of your jobs entitles you to overtime and the other job puts you in an exempt category. And as we'll talk about a little later on, record keeping is a huge burden on an employer. And that aspect, I would tell you, if you have an employee like that, you have to absolutely keep your records meticulously, because if you fail to do so, the presumption is you failed to pay overtime, and that's where you begin to get into penalties. So there are several areas where we think of folks that are exempt, but there's some misconceptions as well. But let me just point out a couple of the misconceptions about the Fair Labor Standards Act that you hear about. When I first started practicing employment law, I would hear these questions from folks, and they would say, well, they're supposed to pay me time and a half. I worked on Saturday. And I've heard that from time to time. I've heard those kinds of things. Or I work the night shift. I'm supposed to get an incentive rate, or things like that. And the reality of it, and I won't go into each and every one of those, but those misconceptions, the reality of the Fair Labor Standards Act goes back to just what I was saying in the beginning. It really only addresses whether you work 40 hours or you work more than 40 hours. And then whether the second part of that is whether or not you're exempt or non-exempt. It doesn't offer things that you might associate. It doesn't say you're required to have mandatory breaks. Things that you might associate with a wage and hour requirement do not fall under the Fair Labor Standards Act. And if you get confused about that, think about it. This is a very, very, very progressive piece of legislation in 1938. So in 1938, they're not going to put in, you probably, the government was not going to take on the battle of saying to employers, you have to give, smoke break, or you have to give a bathroom break, or, Now, with that said, state governments have a lot of those, and even local governments get into those kinds of regulations. But as far as the Fair Labor Standards Act, that's a misconception that is not associated with FLSA. Any questions? Anybody bored to death? All right. I considered it on the way in. My goal, this is victorious if I don't put anyone to sleep during this conversation. So, the other part that's tied to the basic minimum wage is this whole concept of the regular rate. That is the area that gets most confusing because, and I tried to put a little more meat in that part of the outline. So the regular rate is what you contract with your employee to pay. And a contract to pay, to pay wages can be a verbal contract, Bob, come in here, I'm going to raise you to 8 1/4 tomorrow. That's a contract if Bob says okay. So that rate that you contract with them, that's your regular rate. So if you, as an employer, elect to go ahead and improve the basic minimum wage, obviously you can't go below it except in tipped cases, but if you elect to go ahead and improve that, the Fair Labor Standards Act is going to require that you pay overtime at that regular rate. So again, this ties back to your record keeping. This is where records become really, really important. If you have someone that has, the biggest example that I can think of just probably doesn't exist except in really, really limited situations these days, and that's piecemeal work. It used to be that when we had factories in every corner of the country, you worked on an assembly line, and the faster you were, think about the old Lucy Ball, the Lucille Ball show where she's working on the line, and as fast as she can go, she's making piecemeal. And the reason why you go faster is because you get paid more. The record keeping requires you in those instances to keep up with what an employee makes in a regular week, and the employee beside you may be very, very slow. The employee to your right may be much faster, but everybody doing the same work is going to have a different rate of pay, and that's your regular rate. And when those people get into overtime work, they're entitled to time and a half at that regular rate. So again, like I said, I think probably piecemeal is maybe a thing of the past. I'm not sure. I certainly don't have any clients now who do piecemeal work, but you can see where that example sets the table for what you have to do to keep up with your rate. So probably a more realistic or more tangible example, if you've got an employee that is tasked to do a certain job and they do it in the amount of hours that they can get that job done, you may say, I need you to, do X amount of rooms, for instance. If they do those rooms in 30 hours one week and they do them in 41 the next, then you are going to be looking at some overtime, but you're also going to be looking at differing rates of pay. So, you kind of have to keep that in mind as well, keep up with your records for that purpose. Ma'am. Yes, sir.
So if you have somebody working for you for a few years, and that person has over the year received some raises because they're you want to appreciate their work, after reaching a certain amount, they just slap off and they're the bare minimum and don't do anything more. Is there a law that you can bring back their salary or hourly wages above minimum? Can you bring it back?
Not to diverge too far off, but under this form, the Fair Labor Standards Act doesn't, as long as you don't go below the minimum wage, then you can, and again, think of it like this, you brought that person in and you said, you've done excellent work. I'm going to give you 50 cents on an hour for a raise. and the next year they come in and the work is so much better, you're going to give them another $1. You've now raised them $1.50. You've contracted with them basically each time to say, I'm going to, this is your new rate. If they say yes and take it, then they've accepted it. Same thing for the next raise. The same situation. If the only reason that you're saying I'm lowering your rate is because I'm not getting the bargain of my contract, I thought you were doing really great work, now you've fallen off, you can do that. The problem that we as employer-oriented people run into, and I say we because I typically only represent employers, the problem that we run into is outside of this outline, then we start to talk about other issues like discrimination and things like that that can be brought up to say the adverse employment action, lowering my wages, that was done for a prejudicial reason. But if you don't have fear of that as a potential fact pattern, you can. This does not require you to stay at the wage that you last gave the employee. So, and one of I can't remember if I put it under, I've looked at so much stuff with it, I listed some of the common misconceptions. Then there's a great, the wage and hour division for the Department of Labor has a great question and answer, like a frequently asked questions section, and I know that it was addressed there. Things like, am I required to provide my employee with an evaluation every year? The Fair Labor Standards Act doesn't touch that. That's not there, it doesn't touch that, it doesn't touch severance, and it doesn't set your wage in stone. So if you have a legitimate business reason to reduce that rate, then you're okay, you're not locked in. Does that answer? Okay, very good. No, thank you. Any other questions? All right. As I mentioned with the regular rate, the most important part is that when you're trying to calculate what your regular rate for the week is, that includes all forms of compensation that an employee would receive in a work week. So you can have an employee who theoretically never has the same regular rate for the entire 52-week period of the year. So again, a lot of emphasis, a lot of responsibility for the employer to keep up with those wages, because if you run into a situation where you have an employee and based on some compensation, some bonus structure that you want to give them, that becomes part of their regular rate calculus through that week. That compensation, that bonus, you may hit a lag in employment and you may eliminate the bonus or the incentive bonus, and that may end. You could face, without proper record keeping, you could face a situation where down the line they're saying, wait a minute, with bonuses back in March I was getting $10 an hour, but they're only paying me overtime at $8 an hour. So again, the presumption is probably going to be in favor of the employee in those kinds of far-fetched scenarios. Wages, bonuses, commissions, those are all things that would come into play for your calculus. Any other form of compensation, let me see here. Again, where I pointed out, or I mentioned earlier, the employer, even though we have these specific directions about wages and overtime, we're not required to pay on basically, weekly, semi-weekly, monthly, less frequently if needed. Those are all things that the Act leaves us free to determine. But I would tell you, obviously, whatever you do, consistency is going to keep you from getting complaints, because, employees can pick up the phone and call the Department of Labor and complain. The Department of Labor has the ability to come down and audit your records. And that's just the beginning of the trouble if they are on site. Our dear friend Mike Spiegler, who is on the Highlands Incubator Board, we were laughing the last time we were here to do one of these kind of knowledge, actually it was the Business Challenge, but Mike leaned over and said, man, you would pray for an IRS audit if you've ever had to sit through a Department of Labor audit. So I've never been through one, knock on wood, but according to Mike, who manages those things for his clients, they're no fun. So.
I have a question.
Absolutely.
And I just want to make sure I understand this properly.
It would be considered part of their yearly pay. Now, there are other ways that these things are calculated. For instance, like workers' compensation. If you give out, if you pay someone $40,000 and you give a $5,000 bonus at the end of the year, their gross wages for the period of time preceding the accident, it's calculated on a 52-week period, includes that $5,000 bonus. I would tell you in a situation like that, I'm not certain how you would determine the regular rate of pay, because you're actually paying that bonus for an annualized period. That's what you're saying, right? It's a Christmas end of year profitability sharing type thing. And I would want to look at the regulations, but my guess is that in that situation, your intent is that that bonus, that compensation bonus is for their work for the entire year. My guess is that that's going to spread out over the year, and that's going to boost every week that you're talking about. Now, if you've already paid overtime for the work done, it may be that just falls in for that last pay period. I would want to look, though, to be honest. It's a great question. Usually what they're talking about when they're talking about calculating the seminar that I went to, the lady that I saw speak, who does nothing but Fair Labor Standards work, spent a lot of time talking about these types of things, uniform allowances, those kinds of things. And she was talking about those situations where you're more on like a monthly incentive bonus, a monthly incentive compensation. So it may be that a Christmas compensation or that a Christmas bonus wouldn't be considered compensation for those purposes. But if you want to shoot me an email, I'll be happy to try to look and find out. But it's a great question. I don't know completely. Not enough to tell you to bank on.
Right, no, I get it.
Find my place here. And as mentioned, usually it's like baseball, tie goes to the runner, tie goes to the employee. So if there's a way that the Department of Labor can interpret it in favor of the employee, that may be some caution too. So, yes, ma'am.
But isn't the bonuses, isn't there a difference between like discretionary and non-discretionary bonuses that would factor in if it was included in the overtime or not?
I would think it would be. I mean, if it's a non-discretionary bonus, and that's going to be more a part of your bargain with the employee. So if you have a non-discretionary bonus, collective bargaining is what I'm thinking about. When you have a non-discretionary bonus, I deal with employers who have safety bonuses. Those are sort of along the line of non-discretionary, because if the safety standards are met, that bonus comes into play. That bonus is probably going to be calculated in part of your regular rate of pay. Whereas if it's discretionary, you made that, and that's an excellent point. I don't know. That could be the differentiation between the two. But even with that, I think you're talking about a one-time annualized bonus. That would be the focus of my question, based on what we just discussed. How does that factor into an overtime calculation? Because you can't apply it retroactively, even though it might be annualized, but then you're not going to take a $5,000 bonus for someone who makes $35,000 and say that the next pay period they have that much more of a higher regular rate. I wouldn't think, because you're talking about a real disincentive for an employer, because you would never want to pay anybody that kind of overtime. You're talking just excessive amounts of hourly wage. So whereas on a discretionary bonus, or even a non-discretionary bonus, or a discretionary bonus that comes about on a regular basis, because they would tend to be smaller, I would think, so they would tend to be more manageable for the calculus of determining your regular rate. So I don't, to me, those are the kinds, the non-discretionary bonuses are going to be added into it, because those are like sales commissions. If I'm working for you as a sales agent and I go out and I hit my threshold, you're going to pay me my commission at a higher rate because that's what we contracted on. Same thing with a non-discretionary bonus. But I will certainly try to look at it and get an email back to Sandy. All right. As I said, though, with exemptions, and we're hitting on exemptions, so there are several articulated exemptions that come into play. The regulations are fairly tight on what they consider an exemption. There are a couple of kind of themes, although you have to look at each one of these independently. There's the executive exemption, the administrative exemption, the professional exemption, outside sales, and then certain, and this is the way the regs are written up, computer employees. I think we refer to them now as IT folks. And then there's an exemption for a creative individual, someone who's sort of a intellectual property person. One of the key components with each of them is they have to meet a minimum salary. The minimum salary, as I put out, is $435 a week, which on an annualized basis is $22,100. You know, that's a relatively small amount for someone in a salary position these days. You're seeing higher and higher salaries, but that's the minimum. They are typically folks, you know, you may have an executive bonus or things like that to put that salary way, way higher. But you know, the thing to remember if you're questioning whether or not you have an employee who's exempt or non-exempt, each aspect of their job has to be looked at. And typically the things that are common to the Fair Labor Standard exemptions, you have a higher salary. You have a salary that's at least $22,000 or higher, typically very much higher. You have a situation where the person doing the job is given the ability to make independent decisions about how that job is done. So you don't have somebody overseeing the work that they're doing on a regular basis. They're the ones who are assigned the ability to make those critical decisions about what the job does. I know in my world, you know, the attorneys are typically the ones that, you know, if you come to me with a case, you and I make our decisions about what goes on. I don't have to seek oversight from my partners, and they don't seek oversight from me. I have very skilled, very intelligent paralegals who work for me who are probably far smarter than I am, but because they don't have the license that allows them to bill the hourly rate, they have to ask my permission. They're ethically not allowed, even though I have a couple of paralegals who've done this job, you know, as long as I have, but they still have to come to me to say, is this right? Are we okay to do this? Can I do this? You know, I thought you would want to do this. Is this okay? And because they lack that independent judgment, we pay them on a salaried basis just to keep up with their rates. But if they work over 40, then that's their regular rate. We pay time and a half. So failing to do that, you know, puts you in, you know, you even though those jobs are so very similar, the distinction is clear, and one is exempt and one is not. So, you know, I would this is always the section where I get calls. You know, people call up and say, hey, I've got this person, you know, I've got this, you know, I had one call one time, the fellow was a specialized welder. I think he was like an underwater welder with more certifications. I mean, just an artist. And I think the salary was well in the six figures, and, you know, booked 2-3 years in advance because these jobs were so incredibly specialized. And they wanted to know, based on the salary, if that person was exempt or non-exempt. And they couldn't not bill that person's time out at these, you know, $70, $80 an hour rates, which meant that they're paying, you know, 140, you know, they're paying 120 for overtime. But the reality of it was that even as skilled and as specialized as that person was taking directions from the person buying the contract, you know. So you know, it may look like an exempt area, but typically you have to look at every aspect of the job. So, and I've listed the test for many of the common exempt statuses, but I just wanted to put that out there so that if you could get a feel and a flavor for how those things are addressed. Did you have a question, sir? Okay, I thought I saw it. Any questions, anybody with any of that? One thing I would tell you, when you talk about best practices for keeping up with these things, increasingly, when I started practicing law, 25 years ago, in the area, I started out in the area of workers' compensation, and one of the things that we always wanted to know was, what's your job description? Well, the job description had a specific meaning in that area of the law. It meant the things that the person could do and whether they're physically capable to do that or not. One of the things that I'm a firm believer in, after doing a lot of employment law work and other areas of employment-related work, is your job description is really, it's more and more and more important. If you were to suffer a Department of Labor audit on your wages, they're going to want to know if you have job descriptions. And if you have a job description, if you may be mistaken about somebody's exempt status, at least a job description is going to help you explain your situation to the Department of Labor. And they may or may not take pity on you. But in those situations, those job descriptions need to explain those types of decisions. Who makes the decision? Who makes the final call? How much independent say-so does that individual have in the job on a daily basis? Are they allowed to decide to take work or not take work? Things like that. Plus, then the job description would usually start out with your basic wage rate. So you tell, this is what this person makes, subject to raises, subject to whatever types of bonuses. So those are always, it's the last thing any of us want to do is go through a set of job descriptions, pull out the file drawer and dust them off and look at things that were written 20 years ago. But more and more and more, it's critical in the area of ADA. Has anybody had to deal with an Americans with Disabilities Act issue? Your job description should, at the basic level, decide, outline your essential functions. What are the essential functions of your job? If it's not listed on a job description, usually the EEOC is going to go in favor of the employee and say, that wasn't part of the job. So anyway, those are good areas to think about when you get the courage and you've regratted the bathroom and you've cleaned out the gutters and you've finally gotten around to nothing else to do. So you pull out your job descriptions. These are some helpful hints and things to think about. One area there with the administrative exemption, a lot of people say, I've got a secretary or a personal assistant and they're salaried, and so they're not subject to overtime. You could be right, you could be wrong. Typically with the administrative assistant, you're looking at someone who's more than an entry-level typist or an entry-level phone reception person. You're looking at someone who's got a specialized set of skills that they can exercise. Typically they're higher paid, but they've got that ability that comes with training and experience. So you really need, if you think you've got an administrative assistant that you don't have to pay overtime to, my caution to you would be look very carefully. Look very, very carefully, because that's an area that you see a lot of trip up on. I'll skip on over. And I've got examples with a lot of those that just, again, like I said, are to kind of give a feel and a flavor for what exempt versus not exempt is. If you come on down to section 4, where we talk about blue collar workers, so these are the people that the act was really meant to protect. These are the folks who, are, they go out on the job, they do the job, they work as long as they need to get the job done, and especially in the 30s and over, the growth of the industrial, the factory era, these are the folks that had no say-so in what they did. They did what they did, and the statute was designed to pay them so that the employer, in theory, didn't benefit from overworking these folks. And I would tell you that that's really, as long as the statute has been around, that's still the way the statute is written. It's really kind of a neat piece of legislature in the way it kind of takes you back in time. I listed there the duties and tests that are set forth in the federal regulations. That part there where it says 29 CFR Part 541, if you're ever in question about what duties qualify for exempt and non-exempt, that's the area of the Code of Federal Regulations to start. So you could do a Google search and do 29 CFR 551 or 541, and you'd be in the ballpark. Again, like I said, manual laborers, other blue-collar workers who perform work involving repetitive activities. So if you've got someone who's doing the same work over and over, again, the lack of a discretion on what decisions to make with the job tends to go toward the blue-collar side of things. People who work with their hands, physical laborers. Again, like I was saying with the welder, no matter how highly paid they are, it's a duties test as much as it is a salary test. And just for, again, to kind of give everybody some feel and flavor, the list that I have there, the examples, you're talking about maintenance folks, construction folks, carpenters, electricians, mechanics. Good plumber today makes more than, a physician's assistant, but they're still, if you're not an independent contractor, you're going to be subject to, you're non-exempt. Craftsmen, operating engineers, trained locomotive engineers, those folks, longshoremen, fire rescue, police, firefighters, all of those folks are entitled to overtime if they work more than 40 hours. So.
That's a sticking point with the first responders. I mean, there's no question the firefighters and police officers are entitled because they're not exempt. But as they go up in rank, and we're talking between, say, like the chief and the lieutenants, that's where it gets very fuzzy.
Yes.
Because as a group thing, there's, they're always a firefighter, but once they've gone up to rank, like assistant chief or battalion chief or captain, things can change, correct?
Absolutely, absolutely. And I would tell you that if you've got, if your department is, not up to complement, maybe you're between hirings or something like that, they may qualify for both. They may do administrative work, but when the call comes, they're holding a hose or carrying an axe, at which point they would be subject to, again, like I said, the same person doing the same job can be exempt and non-exempt, which is...
You have dual duties.
Yes, ma'am.
Even though they're, let's just say, for instance, you have a captain that might be considered exempt because he's more administrative, keeping time sheets, doing the scheduling.
Right.
But he makes over the 450, and he makes over the 455, paid on a salary basis regardless if he's good or bad at his job.
Yes, ma'am.
Over 10 people. But if he goes out there and he's on his shift with a fire hose, he gets overtime. That's the way I understood it, even though he's classified as an exempt person.
Yes, ma'am. That would be my understanding as well. Yeah, it surely would. And again, that's another good reason. I don't want to sound like I'm evangelical about job descriptions, but that's another really good reason to have those job descriptions, especially at that level. You can, a basic firefighter, you might get by with allowing the job description to set stagnant for years. But when you start to get into assistant chief or fire chief, fire captain responsibilities, just as you're pointing out, these are administrative tasks that they're going to do. Those jobs are going to evolve every year. They're going to have new duties, new responsibilities. But, once they deviate from that carved out set of requirements for the administrator, they can be back in the non-exempt firefighter role. But yeah, that's an excellent question. And a good example of just how tricky the act can be. Again, like we talked about, just as we were talking earlier, the act sets out the minimum requirements for the basic pay. You can always exceed that. State and local governments can force you to exceed that. Those are things that come about, but you can never, collective bargaining agreements may call for you to have a higher, collective bargaining agreements there are some situations that I've heard of, I've never been involved in one, where a 35-hour work week is the minimum, at which point you go into hour 36 by collective bargaining agreement. Now we're into time and a half. I've heard people all my life talk about, I get double time for that. Well, there's no such thing as double time in the Fair Labor Standards Act, but you can contract to that, you can agree to that, and if that's your decision, that's fine. The Act doesn't say you have to, but those are situations where once you do it, you're sort of at least temporarily bound by it, because we go back to what? The regular rate of pay. So if I've decided that by contract or by some collective agreement type situation, I want to pay certain shifts double time, or I want to pay certain shifts incentive pay for the late hours, you're creating a little bit of a situation because you've established some calculus for the regular rate of pay. But again, nothing in the Act requires you to go above it, but and you can contract to all of those things, but there's nothing you can do to contract below the Act. The Act is the floor. So even if you have, somebody, unless they fall into one of those very distinct situations, if you have somebody who says, look, I'll do it for $6 an hour, you can't. There's just, the Act doesn't permit that. The other area that I think for employers that's extremely important is the idea of record keeping. I've dealt with folks in wage records for years and years and years and years. Some very sophisticated, some not so sophisticated, and I've often thought, even though I may be dealing with it in a workers' comp arena, I've thought, are they in violation of Fair Labor Standards? And the answer is no. There's no standard minimum record keeping requirement. Now there are things, as you can see from the outline, there are things that you have to have as a minimum for your records. Certain things that are almost, to give you an idea of the age of the statute, the actor wants you to keep up with the sex of the employee. They want you to keep up with certain things that have specific identifiers about the employee, which tells you you're required to keep this information for federal Fair Labor Standards purposes, but it also emphasizes just how important it is to keep personnel records very, very, very clearly, segmented. So I've listed those things that are commonly required out there: the employee's full name, the employee's gender, address including zip code, birth dates. Again, these are, when you're talking about keeping records on the sex of your employees or the age of your employees, now you're talking about other protected categories. You're talking about, equal employment categories, which is why these records are required. You're also talking about age discrimination categories. So again, things that you have to keep, and they have to be available. The other thing about record keeping is the Department of Labor takes the position that they are entitled to audit your records at any time. I mean, they'll work with you, but basically, because these are required by a public act, they deem that they have access to those records. So just like the IRS deems that it has access to your tax records. So, important things to keep in mind. There's no requirement to keep them electronically. There's no requirement to keep them in any other, you don't have to keep them on site. You can use a vendor to keep those records. But if you need them, if the Department of Labor wants to take a look at them, you better have them. So does that help anybody? Because I always worry about that aspect of it. When you talk about employers and, because there isn't a standard, you're left to make your own standard. Overkill is always a little better, but overkill, when you're double and triple checking yourself on things, sooner or later that's all you end up doing. But so a good common system. Usually most of the software systems that are out there now that we all use and we see, QuickBooks on the cloud, and years ago Peachtree was very common. A lot of those pay record pieces of information, they were designed to keep the minimum. So just be aware of that. Is anybody here specifically required? Are they the ones that make all the decisions about what goes in, like what records you keep? Okay, bless your heart. Yeah, so you get a feel for this, and the general rule is that you're supposed to keep your wage records for 3 years. You're supposed to keep the information that goes into the calculus for your wages for at least 2 years. Obviously, you probably want to keep them both the same length of time, and you may want to keep them a little longer. Any questions?
Mike Scriggler makes me keep it for 7 years.
Yes, I could see that. Yeah, say no more. I could see that. Yeah, he's good with that stuff. And if you're dealing with him, then you're good and covered, because he's, But that's the sort of thing, even if you don't need the services of an accountant or an attorney full time or all the time, it's very good to start out in the beginning and kind of get that feel, and then it's not so much that once you read this you have an idea and you can steer around it, but once you read it you have an awareness of what it can be, how complicated and troublesome it can be. And I will tell you that most of the website for the Department of Labor related to wages and that sort of thing is fairly user-friendly. It's almost written to the employee who's looking to see if they're being paid fairly. So it's usually you can get your answers. So the only other thing, like I said, I put in the appendix there just an example of wages going on, or wage creep going on. Remember that none of this in the Fair Labor Standards Act, because it was one of the first bricks in the employment law wall. It doesn't address the things that we're starting to have to deal with now. If you're, an employer, you're probably dealing with or have heard of, the Family and Medical Leave Act. If you haven't, you probably will. All of these things come into play, and they overlap in some regard. So there's nothing in the Fair Labor Standards Act requires you to pay someone vacation time. Nothing in the Family and Medical Leave Act requires you to pay vacation time, to pay that time off. But just as you're hearing that $15 an hour may be the new minimum wage, we're also hearing that there's a possibility that paid 2 weeks of paid time off is going to be required. It's an ever-changing process, and it's usually always something that they add to the employer's back. Just my bias, but in any event, I'm going to shut it down there and see if there are any questions or anything. All right. Well, I really appreciate you all, and I thank you very much for the questions as we go on. It's always much better to try to exercise what you think you've read. So, in any event, thank you all very much.
Thank you, John.
All right. Hope it went okay. Didn't bore anybody to death? No, nobody.
Absolutely, and this is something we wanted to build on.
We'd love to do that.
All right, thank you.
And also, we want to make sure that you fill out your survey.